Alana, not sure how to pronounce that. I'm going to try summarize or at least paraphrase it. Advise if it's lawful for a landlord to withhold the deposit on the basis that tenants ever paid for water. So is it lawful to withhold deposit for water? No invoices were ever issued to the tenants by the landlord, nor figures or even a WhatsApp or any kind of notification at all that any services amount were due. Tenants had a lease. The lease has lapsed after a year, and now it was on a month-to-month contract and went like that for about 6 to 7 years. Sure, okay. During this times, tenants initiated increases of their own accord. Never got any statements or invoices, never had any communication from the landlord that they had expected a certain amount due for anything. Lease was never renewed. So that's an interesting one. So the tenants enacted the escalation, not the landlord. So my feeling from this is there was a lease, the landlord was totally passive, sat back, received rent, never really communicated, never issued invoices, never issued statements. Amounts were just paid. Escalations were done whether correctly or not, and no water was paid. But now that it's time to pay back the deposit, they want to withhold the deposit solely on the basis that the water wasn't paid. And I mean, my gut on that tells me that more often than not, that's because there is no deposit actually being held anymore. If the tenant was that laid back with everything, all he's actually saying now is, you know what, 7 years, you haven't paid me a cent. At least let me keep, you haven't paid me a cent in water, at least let me keep the deposit. Yeah, I'm not charging anything else. It must be noted clients were given notice via attorney. Clients were given notice via attorney. No breach. The landlord just opted for this route. And it was stated in writing via the attorney they will pay the deposit after the property is vacated. Cool. Yeah, not much context into that. Yeah, so I mean, those are my thoughts on it. I reckon 6 or 7 years in water accumulates to quite a bit. So it's something to consider. But I think as per the conversation that we have, the question really comes up on if the lease agreement says you need to pay water, right? For you to raise a defense that you don't have to pay water is a question of, is it due or isn't it due? Is it unreasonable? Is it being charged incorrectly? The fact that it takes a bit longer for statements to be submitted is not often a defense for non-payment, unless something like prescription applies. And because we're looking at 6 to 7 years, that is an interesting debate because now prescription obviously would apply to, it's a 3-year period. But I suppose now the reality is, from a viability perspective, is 3 years worth of water more or less than the value of the deposit, number one. Number two, I suppose the next question is, does the undertaking to pay the deposit back not act as some form of acknowledgement that kind of negates everything? I suppose that would be depending on the circumstance. What are your thoughts?
Yeah, so obviously, the basis that deposit can be used for utilities that are outstanding at the end of the lease agreement, that's very clear. There's no getting around that. So what is going to have to be paid if it has not in fact been paid? The trick with this is, obviously, the landlord not having issued invoices for 7 years is difficult, because how do you quantify that at the stage that the lease agreement ends? But I agree with you. At the point where, if water wasn't being paid, and it seems that would have been the case, because there's no way for the tenants in these circumstances to have known what the water charges were, because the landlord wasn't providing them. There is going to be a probability that those water charges were not in fact paid, and the deposit could be used in the circumstances. So I think there's a possibility for the tenant to try and fight it, but you might get yourself onto the wrong side of this, and the landlord then does quantify and you might be in for a shock because maybe there are water charges that are still outstanding on top of the deposit. 7 years is a long period of time. There's an issue of prescription, but it might be a fight you don't want to bring up. In respect of the the undertaking by the attorney, I don't think it's going to, it's not, I don't think it's going to be a binding agreement in any way, even though they undertook to pay the deposit. Again, if if those charges were outstanding at the time, and remember, any notice that the attorney had to give was prior to the vacation of the tenants. So in those circumstances, let's say the property had some, had to be fixed up in some sort of way. That deposit is still intended to fix up the property, and I don't think the attorney's letter is going to waive the landlord's right to that deposit in the circumstances in terms of a letter, which in this case would be a notice of termination.
Look, so unless it was some kind of like settlement offer, where you vacate and we promise to pay you this figure or something like that. But I suppose the problem with these questions, and we experience this often, is there's a lot of different scenarios that have played out in our minds. So we've already thought of like 4 or 5 different scenarios on how the deposit would be repaid, how they would have said it, why they would have said it, what sort of notice they would have given, and how the water thing is going to play out. What's quite interesting, and this is more a hypothetical, but I know from the court's perspective, the reality is the amount's due, whether invoices were only submitted a couple of months later or not submitted, unless you can argue some form of abandonment, but I mean, that's a completely different legal principle. The amounts would be due. I've never had a scenario like this in front of the tribunal, but I know that the tribunal sometimes deals with situations differently, and they always try to bring in that component of fairness. So it's just an interesting like a notion that I had now, where be very careful going to the tribunal, because if the landlord manages to quantify at least 3 years of water and escalation over the last 3 years and come after you, may be liable for more. But as a hypothetical, I wonder if the tribunal would actually look at this and go, sorry, you know what, you should have done it sooner, you didn't. I don't feel they need to pay for the water because, you know what, you just never acted.
Yes.
Yes.
It may well be. Yeah, it may well be. But again, it's I agree, but it could go both ways.
Yeah.